I'll try to share a slide myself. Can you see?
Yes, we can. Thank you.
Okay. Thank you, Marijke. Good afternoon, everybody. My name, as Marijke has said, my name is Antonio Álvarez del Cuvillo, and I come from the University of Cadiz in Spain. And in this short presentation, I would like to give a general overview of the mandatory subject, feminist political and legal theories. This course was initially called Feminist Jurisprudence. As you probably know, in British English or American English, jurisprudence means science of law, legal theory, philosophy of law. But in some countries, that is the case of Spain, for example, I think it's also the same in France, equivalent expressions like in Spanish, jurisprudencia, and in France, jurisprudence, are generally referred not to legal theory, but to case law. For that reason, we decided to change the title in order to avoid any confusion. This course is mandatory because it provides some basic skills and some basic knowledge that are completely necessary for achieving the general aim of the master's programs. Marijke has said before that it was the basis for the other courses. I agree with her. What is the aim of the master's program? Dragica have talked before about this aim. This aim is basically to prepare our students for applying gender mainstreaming in lawmaking, in law implementation in the judiciary, in policy making, or in the academic field. But gender mainstreaming requires some kind of theoretical framework in order to operate properly, because that is the basis for the other courses. Indeed, before starting to analyze the legislation and the court decisions, we need to ask ourselves some really important questions, such as, for example, what gender is, or what is gender mainstreaming, or why gender mainstreaming is important or even necessary. What are the possibilities for a gender-sensitive approach in legal thought and in legal practice? Or even, are there any different methodologies or political perspectives in order to analyze legislation or case law? In that vein, while other courses are mainly focused on empirical material, I mean, positive law and court decisions, this course deals with theories and ideas. What are the premises for this course? The course is based on the premise that patriarchy has had a deep influence.
Your microphone is off. It just went off.
I don't know why. It's just in this moment. Now you can hear me? Thank you. I was talking about the premise of the course is that patriarchy has had a deep influence on the construction of legal thought and also political thought. We could remember this quote of Michel de Montaigne: "Women are not altogether in the wrong when they refuse the rules of life prescribed to the world, for men only have established them and without their consent." Well, this is the history of ideas of legal thought and political thought. Because that gender inequalities have been ubiquitous in lawmaking and also in legal interpretation, in law implementation, in all history. These inequalities have been legitimized throughout history, and they have remained basically unchallenged until recent times. As you know, the situation started to change in the 19th century and in the 20th century due to the influence of the feminist movement. Feminist theory has criticized the exclusion of women of legal citizenship, of political citizenship, and also feminist theory has denounced the structures of power that lie beneath some formally neutral dispositions or some formally neutral practices, or even some legal concepts. in order to address this issue, or to address this premise, the course is divided into 4 blocks. In the first block, we explain some basic concepts that are the basis for feminist theory. They are essential. For example, the sex-gender distinction. Also, we have to take into account the possibility of non-binary gender or third gender or whatever. We have to have this wide range of possibilities. And also the concept of gender identity, and of course the notion of patriarchy or masculine domination system. In the second block, the course explores the impact of patriarchy in political and legal thought through history of ideas. This is history, but this is really important to understand the present situation, because this is the premise of the entire course. In the third block, is devoted to understanding feminism and feminist theories in its diversity. For that purpose, we have to depend on the history of the feminist movement and the different types of feminism, like liberal feminism, socialist feminism, radical feminism, postmodern feminism. And more specifically, the course content should also include the evolution of feminist legal critical theory in particular. And the fourth block includes a reconsideration of the central concepts in legal and political thought, always from a feminist perspective. For instance, concepts like democracy, private sphere, equality before the law has to be, they have to be re-examined in the light of the feminist theories. But in addition, gender mainstreaming should be applied to some central political issues. For example, multiculturalism. We have to relate multiculturalism and feminist perspective. And last but not least, it is necessary to analyze some legal concepts that are specially created in order to promote equality. There are special legal concepts created for promoting equality. This is the case of the concept of sexual harassment or the concept of hidden discrimination. Of course, these notions will be addressed from a theoretical perspective without referring to positive law in order to avoid overlap with other courses. To my mind, the contents of the syllabus, I hope the rest of the group agree, are organized around 3 basic principles. First principle, law and politics approach. Second principle, the diversity of theories. And third principle, critical thinking. The first principle implies, law and politics approach implies that legal field and political field are deeply intertwined. They are related each other. And for that reason, critical analysis of the legislation and case law requires to explore not only legal thought, but also political thought, because that we are talking about feminist political and legal theories, not just feminist legal theory. It's a wider sense of feminist jurisprudence that we are addressing here, because political and legal are intertwined, especially when we are trying to criticize the legal system as a whole. The second principle, diversity. We should take into account the diversity of theories. You all know that feminism is very diverse. There are different theories. They often contradict each other or clash on each other due to epistemological differences, ideological differences, or even strategical or practical differences. And this is not just a theoretical debate, because there are many heated debates about concrete practical issues. Therefore, we cannot present a monolithic overview of feminist theories. We have to report that there are a lot of debate, a lot of discussion. And the third principle is related to the other, critical thinking. Critical thinking is essential. Critical thinking, of course, is really important in all university courses, but in this course in particular, I think it's especially important. even more than usual. Why? First, because critical thinking is necessary to apply gender mainstreaming. We have to be critical with the dominant discourse, with the mainstream discourse in legal and political thought in order to change this discourse or to include the feminist approach. But also critical thinking has to be applied to feminist theories in themselves, especially because they are diverse. So we have to take into account that they are diverse, they often contradict, so we have to be critical with the hegemonic system or the dominant discourse, but also with feminist theories. And of course, the students have to be critical with the views or the perspectives of the teachers also. We are not gods of knowledge that are giving the truth. We are just trying to train our students in critical thinking. Because the methodology of this course has to be focused on discussion and debate, even more than in other courses. Probably discussion and debate is important in every academic discipline, but in that course it's particularly important. To sum up, this course provides a philosophical perspective that is essential for understanding and applying gender mainstreaming. So, as Marike has said, it's the basis of the other courses. And also, we expect that the students improve their critical thinking skill. That is a basic intellectual skill that could and should be applied for applying gender mainstreaming and for other issues in their professional careers. So that's the end. Thank you very much for your interest and your attention.
Dear Antonio, many thanks. That was a great introduction, and I think we have all a better clue about the course. I would kindly ask Professor Tanasije Marinković from the University of Belgrade to give a short presentation about the course Human Rights Law and Gender Perspective. So the floor is yours, Tanasije.
Hello, Marike. Hello to everyone. I hope we all hear each other. And I'm so happy actually that we can all see each other and that we can exchange our experiences with respect to the work on this very important project. I will, as Marike said, I will inform you of the gender perspective in human rights. And I have actually prepared a PowerPoint presentation which is based on the textbook chapter that we are working on at the moment. So that was my idea of presenting you the one way of understanding actually the curriculum, the syllabi of this course. So now the famous sharing, share screening. Yes. I guess you can see it. Can you see my presentation?
We can see it's a bit small. Now it's better. So
yeah. Okay, sorry. Now I lost it. Yes. So gender perspective in human rights law, one of the mandatory courses and one of the chapters in a textbook which we are all contributing to. So let me start with saying who are the authors of this chapter. It's Professor Marko Evola from LUMSA, Julia Jungfleisch from Saarland University, and Tanasije Marinković myself. This is the overview of the chapter. Apart from the introduction and conclusion, we have one section which is of, let's say, more theoretical nature and which is a sort of connection with the feminist legal and political theories. I will explain also why there is this section within this chapter. And then we opted to present gender perspective in human rights law following the two classical classifications of human rights law, the first and the second generation of human rights law, and to give an insight into how the human rights law are perceived within that perspective. Now, the from women's rights to gender equality, that will be a tentative title of this chapter, which will be dealing with those concepts which are relevant for the understanding, those theoretical concepts which are relevant for the understanding of the human rights issue in the gender perspective. Human rights are debatable by themselves. They're the apex of the legal system, we all know that. But we should also sometimes, and we are regularly reminded that actually being at the apex of the legal system, they presuppose the maximum of consensus, but at the same time, before that consensus is reached, there is a lot of debate as to how these rights should be regulated and how they should be guaranteed. So there is always essentially and intrinsically controversy about human rights. And that controversy is even more stressed, is even more present when it comes to gender perspective in human rights. So gender perspective actually contributes to the complexity of the human rights debate. It makes this human rights debate even more richer and more nuanced. So in order to understand actually what are the issues and why certain countries have opted for one type of solutions by the others for the others, we consider that it would be important to give an overview without entering into the details as the course and the chapter on the feminist legal and political theories would do, to give those different perspectives which actually inform the positivist human rights debates in the context of the gender equality. So one of those perspectives is the gender neutral approach. I mean, we have just heard that it's actually within the feminist scholarship that the idea of gender equality got born, and thus the title From Women's Rights to Gender Equality. So there is a liberal feminism, there are other types of feminisms, and we wanted to point out that each of them actually inform in its own way the proper human rights debate, positivist debate, as to how certain rights should be regulated, how certain rights should be implemented. So it could be also gender differential approach. There are also those theories and those approaches which problematize the binaries of male and female and which insist on the questions of identities and multiple identities, or those within the structural feminism which insist on the general reconfiguration of institutions and not of just minor or detailed changes within the institutions or within the concrete rights. Now, going to the blood and flesh of what human rights are, our third section is devoted to the gender perspective in civil and political rights. Already mentioned by Honorable Judge Jelić, the gender-based violence is at the apex of this group of rights. So the protection of women in principle, protection of their life and protection of their physical integrity. Here we approach different types of violences. So both those which lead to the loss of life, but also which lead to different type of violation of physical integrity, including, let's say, genital mutilation, violence is related to the giving birth and pregnancy, or domestic violence, which has also sometimes psychological aspects and is a type of violation of psychological integrity. And there we also deal with online violence, so hate speech, which and different types of stereotyping, which actually produce, provoke, and contribute to this type of violence. We, as it is pointed out in the title of this subsection, we've very much focused on the Istanbul Convention and on the different methodologies developed within that convention, such as policing, prosecuting, protecting, and punishing. So both focusing on the victim and on the perpetrators of these type of violences. Then gender dimension of contemporary forms of slavery and trafficking in persons. We deal with all types of slaveries in the wider meaning of the word. So both slavery, both servitude, and trafficking of persons, focusing as well on the position of migrants. Religious freedom for and against women, another civil right. And I would like to, this was probably obvious from the beginning. We did, for the purposes of the general function of the textbook, we did give this structure, which is simple and which is student-oriented. But at the same time, we do not hide, and we do not run away from problematizing relevant questions and issues. For example, in the context of religious freedom for and against women, we are faced with a twofold problem. So on one side, we could say that religion has to be understood in the context of also women's perspective or woman's perspective, and the particularities of their type of exercising this freedom. So numerous cases in the case law of the European Court of Human Rights point out to those issues, such as SAS versus France or Dalab versus Switzerland, which are related to the use of religious veils and how it affects women, for example, in public spaces. So there is that aspect of perceiving religious freedom for women, but at the same time, religious freedom sometimes are used against women, and we have that perspective. It's not just in the Islamist countries that we see stoning of women and other types of violences, also to some extent justified by the religion, but we also see it in the liberal democratic societies, in European and American societies, with the 2009 Manhattan Declaration, which actually wants to save religious institutions and religion from the application of the anti-discrimination law, which affects, of course, the position of women both within the canonical structures of the church and outside in the family, in the way her role is perceived by the dominant religions. Then I continue with the article with the right to life, private life, respect to private life, women's reproductive autonomy and gender-affirming surgery. So different aspects of women's reproductive autonomy, including prohibition of abortion or allowing abortion under very restrictive conditions, or the question of third gender, as we have seen in the recent judgment of the German Constitutional Court, Federal Constitutional Court, which allows for the administrative recognition of a third gender, and also gender-affirming surgery, and again, administrative consequences of the gender-affirming surgery. So not only to be able to change the gender surgically, but also to administratively recognize such a change. Then empowering of women, a topic that we will discuss more today, and which concerns the political rights of women in the broadest meaning of that word. We have seen that actually women started enjoying these rights in as much as many other rights on an equal footing much later within the history. Hence the question whether some corrective mechanisms should be used to empower women. Quotas are one of them. As Professor Gigerich already announced it, in many countries we have seen that the courts, especially constitutional courts, were unwilling to validate these kind of inequalities. And then we come back to the theoretical aspect, because then we have to explain why we should consider it, we should take maybe gender differential approach rather than gender neutral approach. Hence the importance of that kind of introduction into these topics. So many constitutional courts have annulled these legislative solutions, as a result of which constitutions themselves had to be changed. And let me also say that this empowering of women is not also only related to quotas for the appointment to and for the election to political bodies. They're also present within other branches of government, judiciary, for example, and also on an international level within the international institutions and not just national institutions. And access to justice for women, so very important question, the procedural mechanisms, the institutes of procedural law, which are intended to actually enable the full enjoyment of all these rights. And again, Judge Jelic mentioned the judgment of Opus versus Turkey. There are many actually instances, that's the most famous for sure. Many other judgments, Konstantin Markin, and other judgments within the case law of the European Court of Human Rights, where we see that some procedural institutions were amended in order to, or were reinterpreted in order to enable for an effective protection of women's rights. So it's one thing to provide for substantive rules and principles, but another to provide for an effective legal judicial protection. And the European Court of Human Rights, for instance, has shown that kind of broad-mindedness when it came to the status of the victim, to its understanding of who is the victim and who can be the victim, when it comes to the exhaustion of domestic remedies, to that issue, whether the remedies are exhausted, with regards to the time limitation and so on and so forth. So we see that there are different legal mechanisms, procedural mechanisms through which the access to justice for women can be more effective. And I know that my time is running out, and I will so finish shortly. We also tackle the gender perspective in economic, social, and cultural rights. So we do not disregard the importance of these material, if you want, in a way, preconditions for the enjoyment of all other rights. And those preconditions are both of economic and social nature, but I would, within the context of this project, I would especially point out the importance of that cultural dimension, which is related to the gender education, filling out the gender education gaps, and understanding education as a pathway towards gender equality. So we focus on both those, on all three dimensions, which are presuppose positive engagement of the state in allowing and making possible the full and proper enjoyment of women's rights and gender equality. Thank you.
Thank you very much, Tanasije. That's a great program. It's a lot of topics in there. So thank you. And I would like to ask Professor Marko Evola from the LUMSA University to share and give an introduction to the course of EU and international law and gender equality. So Marko, are you there?
Yes, I'm here.
Perfect.
I should. Okay.
Super.
Now I'm here.
The floor is yours.
Thank you. Good afternoon to the women and men who are attending this meeting. I'm very happy to take part in the meeting, to have been happier to be in Saarland. I want to thank the colleagues from Saarland for entrusting me with the task of presenting the content of the course of international and European law, which is the output of a great debate between the scholars coming from the 5 different universities taking part to this project. I'm sorry, but I have no written presentation since I discovered that my computer did not work well just a few minutes before connecting, and that's also the reason why I have to move to another computer, and which is my wife's computer. So the name, as you can see, it's not mine, but my wife's name. Before taking into consideration the content of the course, I want to say a few words on the reasons for considering part on mandatory courses. International law has been playing a growing role in domestic laws. It has gaining a growing importance. It does not regulate only international relations, but also pervades domestic legal systems. And this is one of the reasons why we thought that dealing with international law was a necessary step in order to improve the knowledge of students as regards gender and law. Furthermore, the European Convention on Human Rights as well as EU law are playing an important role in the domestic legal systems. I have to say that all rulings on the Italian Constitutional Court dealing with human rights mention the European Convention on Human Rights, make reference to the case law of the European Court of Human Rights. And therefore, this interplay between domestic laws and this European Convention on Human Rights is one of the reasons why, once again, we thought that dealing with the European law is necessary. We use the formula European law because the course will focus on both the law of the European Union as well as the human rights protection system which has been enacted within the Council of Europe. There is also a further reason for combining international law and European law in one course. We know that scholars have focused on international law to revise international law and its concepts from a women's point of view. These studies have contributed to reshaping studies on international law, have contributed to reshaping the role of international law. Women scholars have demonstrated that international was the product of a male culture and male activity. And they urge scholars to revise international law and to revise the role of women and the contribution of women to the development of international law, which, as I said before, plays a role in domestic laws, which distributes power and resources. But not a similar trend as marked the studies on EU law. There is a kind of prejudice on EU law, that EU law can't tackle the most important challenges concerning women's legal status. EU law has no competence on gender-based violence, has no competence on family or reproductive rights, which were quoted before. Or if you consider EU law from the point of view of homosexuals, the European Union has no competence on adoption of children, on the legal status of same-sex couples. So there is the idea that the EU law can give a small contribution to the development of gender law from the perspective of gender, which is there's a prejudice and is also not perfectly correct, since despite the system of competencies of the European Union, EU law has taken ground and has regulated mainly to the case of the Court of Justice fields which do not fall within the competence of the European Union, but which could affect EU law as it exists. The KB case is a very good example in this perspective. The Court of Justice ruled that the UK law on birth certificate was in breach of EU law because of the consequences of the enjoyment of pay. So if the European Union is able to develop and widen the scope of these rules thanks to this way of constraining EU laws, the idea that the European Union cannot contribute to the gender perspective and to improvement of women's rights is partially wrong. Combining international law and European law is useful because I think the studies on international law can contribute to development of studies on new law from a gender perspective. There are a lot of scholars that with equality within EU law and consider the way in which equality has been guaranteed with EU law, but I think there are further steps to be taken in order to improve a gender knowledge on EU law. And international law can give a contribution in this perspective and to the achievement of this aim. So this are the reasons why we first decided to include international law within mandatory courses, and this is also the reason why we decided to combine international law and European law. Such a choice, I think, is also important if you consider the recent events which have taken place as a consequence of the COVID-19 disease. We know that the pandemic has affected women's rights more than men's rights. And there is a very interesting debate within scholars about the role that international law could play in protecting female rights. I want just to mention the right to abortion. We know that many states of the United States are preventing women from accessing to hospital, claiming that the dangers which were connected to the disease prevail over the need for abortion. Could international law support the claim for the right to abortion in these cases? We know that unemployment as a consequence of the COVID-19 is affecting women more than men. Female unemployment is rising. Can we make use of the concept of positive obligations to argue that states are obliged to support female employment in order to face the consequences of the crisis? So international law and EU law could contribute to strengthen those fundamental rights which have been weakened during the pandemic crisis. I was just to mention the content of the course and try to highlight some of the points which are crucial in the issues we're going to deal with. The idea is to move from international law and the revision of the traditional concepts of international law in order to revise the way in which international has been developed, and in order to revise those concepts upon which international has been grounded. That's the reason why the first point of discussion will be the traditional gender-neutral approach of public international law, which has always covered the male influence over the development of international law. In this perspective, it will be of interest to reason with students on the role that scholars, judges, attorneys law could have in order to improve a different way of developing international law through the revision of traditional concepts. Furthermore, attention will be paid to some fields of international law, such as international humanitarian law. As discussed in the development of international humanitarian law, it's quite interesting to highlight that this law assumes that women are a vulnerable group rather than focusing on equality between men and women in the application of international humanitarian law. So this is a clear example of the consequences of a male approach toward the problems involved in conflicts. Furthermore, we will take into consideration, of course, the CEDAW, which is one of the most important international instruments devoted to the protection of female rights. And I think it's one of those instruments states should avail themselves or in order to face the pandemic crisis. Once again, the perspective will be not only to assess rules as they exist, but also to consider if these rules are still offering strong instruments to tackle discrimination against women. I think that there are rules which need to be revised because they belong to an era which ended not in recent times, but just many years ago. The second part of school will be devoted to the European law. The European law, as I said before, is based on the system of the European Convention of Human Rights, first and foremost, and then on the EU law system. Judge Hirsch already mentioned the role of the European Court of Human Rights in tackling the challenges of gender equality through rules which were not conceived in order to protect women's rights or transgender rights or sexual rights. As a consequence, the course will focus not only on provisions, but I think mainly on the case law of the court on human rights and on development of the case law of the judges sitting in Strasbourg. This case law is of utmost importance also in order to understand the development of the case law of the Court of Justice of the European Union, which is the third part of the course. We know that EU law has fought against discrimination, but we know that most of these rules were conceived not to take into consideration women's rights, but rather in order to ensure fair competition within the internal market. So they were part of those rules we enacted the European Union in order to support the internal market. And this feature has not disappeared despite the improvement of the protection of human rights in EU law. And I have to say that the role of the Court of Justice is a little ambiguous in this perspective. Okay, I think the time is going to end. Okay. However, we will take into consideration primary and secondary laws of the European Union as well as the case law Court of Justice. There is one point which I want to focus on in a very short time, and it's the latest reason for combining international law and European law. Judge Jelic said just a few minutes ago that the experience of the Court of Justice will be helpful in the working of the Court of Human Rights. I think there is the need to combine all these systems together. I was quite surprised that the Court of Justice makes no reference to the CEDAW and uses the case law of the European Court of Human Rights only to support some rights. It's a cherry-picking approach which marks the case law of the Court of Justice. Court of Justice opens the doors to transgender rights, but has never made use of the case law of the European Court of Human Rights as regards homosexual couples. I think that the interplay between different systems and the knowledge covering all these systems could contribute to the improvement of all of them, since there is a dialogue between the different systems of protection of fundamental rights. Sorry for being too long, and thank you very much.